Good evening, Council. Jacqueline Nkutia, Commissioner. Welcome.
Good evening, Council. My name is Caroline Zilani, Commissioner. Karibu.
Good evening. My name is Charity Kisotu, a Commissioner. You're most welcome.
Thank you.
Good evening, Chair. Mwanza Umbati, Commissioner.
Thank you.
Yes, good evening, Wakili. My name is Anthony Mrima. I'm a Commissioner. All the best.
Good evening, Wakili. Fatuma Sichale, karibu sana.
Thank you.
Good evening, Oluwande Evelyn. You are welcome.
Thank you.
Good evening, Dorcas Odur, Senior Counsel, Commissioner.
Yes, thank you very much for that introduction. Mr. Hassan, you can start by telling us your county and your ethnicity.
Thank you very much, my Lady Chief Justice. My county is Garissa County, ethnicity Somali.
So now we'll go into the interview part, and I will ask you 4 questions, which you will answer in about 4-5 minutes. I want you to briefly tell this commission about yourself, and then who is Ahmed Issack Hassan. I hope you know what I mean by who is.
Yes.
Not what you've done, but who is Hassan. Besides what you have done, there is something that you are. And in that, you'll also include the skills that you're going to bring here, the knowledge you're going to bring here, and the value you're going to hand to the Court of Appeal. So I think those are 4 or 5 questions which you'll answer together.
Okay. Thank you very much, my Lady Chief Justice and Commissioners. I am a lawyer, a legal practitioner, a public servant, an international civil servant, and a family man, 55 years old, married with 4 children. I'm currently the chairperson of Independent Police Oversight Authority, IPOA. I was admitted to the bar as an advocate in February 1995. I have 30 years of practical experience in the practice of law, election administration, and public service. I have practiced law with the law firm of Mohammed Ibrahim and Associates. The late Ibrahim was also my partner when we formed the Ibrahim and Issack Advocates. I became the managing partner of the firm. I practiced in all areas of law. I then went into public service when I became chairman of the interim Independent Electoral Commission in 2009. I helped in setting up the new commission. I oversaw the adoption of the new constitution for Kenya. On 4th of August 2010, I conducted the referendum. After that, I also oversaw the setting up of the secretariat from scratch of IEBC. I became chairman of the Independent Electoral Boundaries Commission, IEBC. I oversaw the first boundary delimitation exercise for Kenya after the census. And that boundary delimitation exercise is what we are still using to date to elect our members of parliament and our MCS. It's long overdue for a review. My lady, after I finished with the election, I joined the International Civil Service. I became an international consultant on governance and elections. I worked with the UN election support projects in Somalia and Afghanistan, and where I advised the UN country team and the electoral commissions on elections. I became a commissioner, an international non-voting commissioner of the Electoral Commission of Afghanistan. I was nominated by the UN and appointed by the president to sit on the body. And we conducted the election for president and parliament in 2018 and 2020. I came back. I then joined the Africa Union Election assistance mission to Somalia and South Sudan as a senior election expert and a senior election dispute resolution expert. Again, I help in advising the African Union chairperson and the commissions. I have come back to Kenya again in my capacity as an advocate. I was appointed to chair the Kenya Industrial Property Institute, KIPI, which is a government of Kenya parastatal responsible for intellectual property rights regime. And I was there for 6 years as the board chair. And I oversaw the reform of the institution, and before finally becoming chairman of IPOA. And so, my lady, I bring this total experience of 30 years in election, administration, in public service, in working in government, working for international organizations like the UN and the African Union. So I want to bring home this cumulative experience into the bench. And this is why I think I want to cap my ambition experience.
Thank you. Just as a follow-up, you are now at IPOA. How long have you been at IPOA, and why do you want to leave so soon after?
I was appointed on 6th of December 2024. IPOA, my lady, all the jobs I have held were jobs that required advocates of the High Court of Kenya, whether it is interim independent electoral commission, IEBC, KIPI, or IPOA. They all require an advocate of the High Court with a certain number of experience, 15 years or 10 years. So I had applied for Court of Appeal. You know that I appeared before you in 2022. I was not lucky. I again applied in 2024, but the Gen Z thing happened and then it was cancelled. My ambition has always been to join the bench.
Very well.
As an advocate, I think the highest goal you want to be is to join the bench, become a judge.
Thank you.
And IPOA is good. He's a chairperson there.
Yeah.
It's at the level of a high court judge also. Yes.
Thank you. The next set of questions will be taken by Justice Ushale.
Thank you, Honorable CJ. Wakili, one or two questions from me. We will move away completely from electoral law and we will discuss land law.
Yes.
Now, we all understand what adverse possession means.
Yes.
And the position of the law is that illegal occupation, such as trespass or squatting on someone's land, can form the basis for a claim under the doctrine of adverse possession. Now, the question that I'd like to ask you is that what if the entry was on account of post-election violence, as we witnessed after the elections of 2007? Yes. What if the entry was as a result of that post-election violence? Can somebody be on that land and then after the 12 years claim adverse possession?
I think yes, he can. If the person who is contesting the claim did not make any effort or didn't notice the squatters to either claim his title or otherwise show that he's an interest there.
All right, that's actually correct. So you can enter on account of the post-election violence, and if the owner of the land doesn't make a claim and you squat on it for more than 12 years, you can go to court and seek orders for adverse possession.
Correct.
But supposing
Yes.
that occupation by these people who have come into the parcel of land as a result of the post-election violence, supposing the occupation on that land is violent. They are on that land and they are violent. Never mind that the entry was illegal, but they are on the land, but they are violent.
Yes.
Does that change any equation?
Yes, I think if they start using violence to either maintain the ownership or the defend of the owner, the real owner, that changes the character of the claim. They become now aggressors, really.
So if a suit was to be filed for adverse possession and it comes before you,
I will have to look at the facts of the case clearly, because ultimately it is to ensure there is fairness in the whole process.
all right, but you're saying that if there was violence, then
Yeah.
they are not entitled to adverse possession.
They are kind of defeating their own claim.
All right. Now, of course, I appreciate the fact that you've been in legal practice before you joined public service for a long time. And in the course of your legal practice, if a client came to you, still on the aspect of adverse possession, and they're seeking advice from you, they have a parcel of land in a far-flung area of this country, and they're seeking your advice on how they can prevent adverse possession, what's the advice that you would give them?
I think the advice first is to secure the land. You should not allow it just to be vacant without any development on it. If possible, you can fence the property, secure it, and put a notice that this land is not available for sale or for anybody else. That will be my first advice. And secondly, is to take title deed if the land is not surveyed, to survey it and then have a title deed issued in his favor.
And if there are squatters on the land?
Evict them, get a court order to evict them before they claim adverse possession, especially within the 12 years.
Okay. And if there are persons who are leasing the land?
These are lease, they are on leasehold.
Yes.
They are entitled to stay by virtue of the lease agreement. But if the lease expires, then you will ask them to vacate the land.
So you must have a lease agreement.
Yeah.
Right. Thank you.
Thank you.
Yeah, look at me directly. I think it's someone, so it's AG. Okay, AG. Welcome.
Yes, good. How long did you say you've been in IPOA?
1 year.
For 1 year.
Yes.
I want to ask you something about restorative justice.
Yes.
We all are aware of complex international crimes, financial crimes, transborder crimes, which are very violent sometimes and very complex.
Mm-hmm.
And we know very well that in investigating these matters, courts have become active participants.
Yes.
Especially when we go for coercive orders. Likewise, the victim has also become a very active participant. When we're thinking about human trafficking, human smuggling, drug trafficking, asset forfeiture, the victim is very, very, very active in litigation. But despite all this, we have not developed jurisprudence in restorative justice. Therefore, there's limitation of the responses of the criminal law. What is your view? Taking into account that even on interlocutory matters with regard to coercive orders sometimes find their way to the Court of Appeal, what is your view? Why is it that we have not developed that jurisprudence?
Well, I think first and foremost, the Attorney General will advise the government and the country on the appropriate law to adopt and the regulations. But that aside, I think we follow an international regime. If we are a party to the International Convention for the protection of people against, for example, human trafficking or sex trafficking, then we need to be able to then translate that into a domestic law.
Which we have.
Which we have.
Yes.
Yes. So I think it is a lack of maybe political will to proceed with the regulations and the procedures. That could be one.
Mm-hmm.
But I think also if the victims involved, we have not yet brought out what kind of reliefs are available to the victims of that kind of crimes like the trafficking. Am I clear, IG?
I'm listening.
Yes.
It's okay.
Oh, okay. So I will assume that I will assume it's because we have adopted the law, the international convention, but we need to act on it, perhaps because of lack of political will, I'll say.
Okay. Secondly, we think or we agree that our constitution is still very young, and we are all grappling to interpret it in the best way possible. Now, what reforms or innovations do you think are necessary to ensure that the Court of Appeal remains responsive, credible and fit for purpose, taking into account our evolving constitutional democracy?
Yeah, the Constitution is 15 years old now, so barely still young. In other countries, I think, like in Ghana, they were able to do a review after 10 years. We have not done that, but I think it's possible that now we are beginning to have discussions about possible review of the Constitution. It's a very political and emotive issue, and sometimes divisive. However, coming back to your question, Attorney General, I think the Court of Appeal has to approach the same way that the High Court and the Supreme Court has approached interpretation of the Constitution, in a purposeful manner, to ensure that it lives up to the values upon which we agreed as a nation to have this Constitution, and to ensure that we should not lose focus of the fact that this is a people-centered Constitution. The people are at the heart of the Constitution-making process in Kenya, and it is for them that we are doing this.
Have you heard of the term judicial adventure?
Judicial adventure?
Yes.
No, I've not heard. Maybe you can educate me on it.
How would you define activism to an extreme end?
Well, yes, I've heard that judicial activism, judicial restraint, judicial...
but I mean, I'm interested in judicial, maybe let me say judicial overreach then.
Overreach.
To the extreme.
That is as opposed to the judicial restraint, which is the two opposite ends. An overreach is, I think, where the judiciary or the judge is entertaining questions that are not justiciable, they are not yet ripe, or they are pending in another body of government, like Parliament, or that yet the issue is not ripe for debate in court.
So what legal philosophy would you apply not to end up undertaking judicial adventure or overreach?
I will apply judicial restraint. I will look very clearly at the law. I will contextualize the law. I will look at the facts of the case. I will look at what the courts have said before, especially the superior courts, like the Supreme Court, and then apply the law accordingly, without entertaining what could possibly be a political question within the judgment.
Can you categorize that underpinning opinion or application of the law?
I think the BBI judgment had a lot of examples of in and out of judicial overreach, judicial restraint.
Now I'm referring to you.
Yes.
When you are applying the law and...
yes, if a matter is being debated in Parliament, for example, and it is not a treat, it's maybe in the third reading, and someone has come to challenge the process, I will not be quick to join in and give an order to stop that process. I will wait for Parliament to complete its process, then we can challenge the merits, both on process or on substance.
Okay.
Thank you.
Thank you.
the Honorable Attorney General. If we could have Commissioner Mwanza.
Thank you, Chair. Good afternoon. Good evening.
Good evening.
I have a couple of legal issues that I want us to discuss. And the first one is on the power of the jurisdiction of the Court of Appeal in 5.2b applications. Would you say, or is it your view, that in 5.2b applications that affect public interest matters, will the principles that are applicable the same as one of a commercial nature? That's the first one. And then secondly, is there an extra test that has been set out by the either the Court of Appeal, the Supreme Court, in evaluating claims of a public interest nature?
Thank you, Commissioner. I think apart from the other two grounds that we know of, which is that it must be having an arguable appeal, and number two, if the order is not granted, the appeal will be rendered negatory. Those two are common.
Yes.
But the third one now is a matter of public interest.
Yes.
And it must be one that is able to transcend the parties involved.
Okay.
And the order being sought has a bigger effect and impact on the country and the public at large.
Okay.
And I think also if from the Supreme Court, I think what I have read is that if also a matter is raising a novel issue, which is quite in the law, maybe also it will be considered.
Okay. Now I want to proceed further on that issue. If you can tell us what is the jurisdiction. There's a special jurisdiction under Article 163(4)(b) of the Constitution of the Court of Appeal. Are you aware of that jurisdiction?
To hearing appeals from the High Court?
No.
Other
No.
appeals from other?
No.
Yes.
You have your Constitution there?
Yes.
Yes.
163?
163(4)(b).
Yes. In any other case in which the Supreme Court or the Court of Appeal certifies that a matter of general public importance is involved.
Yes.
Subject to clause 5.
Yes.
Yeah.
You know about that jurisdiction?
Yes.
Now, are you aware of any case that has settled the test that the court would ordinarily apply to satisfy 163(4)(b)?
I think the case law on that is that the matter must be one of which affects the public at large.
Yes.
It transcends the individuals.
Yes.
And that it's raising an issue that is novel and a new thing.
Okay.
Yeah.
Would, for instance, two conflicting schools of thought or decisions in the Court of Appeal satisfy that test?
Two conflicting judgments of the same court.
Yes, the Court of Appeal.
Yes.
Yes. So you have one school that deals with the matter in one way and another. Would that satisfy the test under that article?
It may, but I must add this.
Yes.
Judgments of the Supreme Court are binding on all courts.
Not the judgment of the Supreme Court. No, I'm saying.
Yes.
So because we are looking at the jurisdiction of the Court of Appeal in that article, and you have two conflicting judgments in the Court of Appeal, and then a party comes maybe in a third one and says there are two schools of thought on this, and perhaps the Supreme Court ought to clarify or ought to settle that issue. Would that be a test that will be applicable under that article?
Correct, I think.
All right.
Yeah.
I had opportunity to read your book.
Referee.
Yes, the referee. I think you call it the
Referee of a dirty, ugly game.
yes, referee of a dirty, ugly game in the theater of Kenyan elections. And I noted that some of the personal challenges that you reflect upon on that book is about one, internal splits and pressures that were within the commission at your time,
Yes.
and two, the political pressure.
Yes.
Perhaps you can explain to us how you were able to overcome that and then juxtapose it with what you seek to achieve through this interview.
Well, when you are chairman of the Electoral Commission, and especially because you are the returning officer for the election for the president, it is always a very difficult job, trying to maintain balance and give the people of Kenya confidence in the election results. And so how you conduct yourself, how people perceive you is important as much as the way you do the election itself. And so in my experience, I think, is to carry along the commissioners. When you have a divided commission, that is the first red flag. The first red flag in the outcome of the decision. I try very hard to build consensus. If there were divided opinions, I will have a meeting before the meeting to understand where a commissioner is coming from, what are the issues. If we have to, we will postpone the meeting itself until we eventually make a decision. Or if we have a commissioner who is very strong about an issue, we allow him to record a dissent. But during my time, there was no division. And because I practiced leadership, which was very accommodative, I was humble. I was more or less younger than some of the commissioners, but I listened to them and I took advice from them. But more importantly, I was also independent. I was not scared of the politicians, because politicians, I don't know if there are any here, I apologize to any who are politicians, but they like to intimidate you.
Yes.
They like to intimidate you, and once you accept one intimidation, then it's like it's going to follow one after another. They will tell each other that he can be done this way. So I think, I remember when I was appointed first as chairman of Interim Independent Electoral Commission in 2009 May, we were still in the coalition government. The post-election violence was still over, but we still had people in the IDPs. And when I was appointed, I was very conscious of the two governments, the PNU and the ODM government. It was a shared government. And I went to see General Ali, who was the Commissioner of Police, and asked him for advice. I asked him to advise me how to deal with the politicians. And his advice was very good. He says, never exercise a discretion in their favor. If you have a discretion at all, don't give it to them. Just stick to the law. Don't give them any space. And I think I did that. He was also known to be a very independent commissioner of police, who was very strong in the way he led. I believe in my time, I did an election. It was challenged in the Supreme Court, and the Supreme Court affirmed the election result. And so my point is, you must carry along the commissioners. If you don't, that's a red flag.
I remember, just to follow up on this question, in your book you discuss about who owns the electoral process.
Who?
Owns. Yes.
Mm-hmm.
Whether it is the people or powerful political interests.
Yes.
And how are you able to reconcile these two, and who eventually triumphed?
For me, it was the people who always won. The reason why elections since 2010, The reason why there's no serious violence after elections, especially in other parts of in other elections, is because people are able to see, apart from the election for president, which is always controversial and always sensitive and always divisive. But if you look at the election for governors, senators, MPs, MCS across the country during my time, people were able to see their will. When people see their will in the election, they voted for MCS, they see them. They voted for MPs, they see them. So what happens in Bomas at the election for president did not really concern too much, to the extent that the whole country was at war. So always the will of the people must be reflected in the election. That's how we are able to maintain political stability and peace.
Would you say then that you are an individual who exhibits strong independence in terms of your mandate and whatever undertaking that you endeavor to do?
Yes, I do that. I am very strong. Everyone I have worked with, from IIC, IBC, and even at IPOA, they will tell you that I'm very strict. I insist on my powers and authority, and I'm able to speak truth to power.
Okay. Yes. And lastly, what would you think, or in your view, what would be your greatest strength that you would bring to this court if you were to succeed?
I think I bring my experience in election work, my experience in public service, my experience in government, because I have worked at the highest level of government, being able to engage with all ministers, presidents, prime ministers. I have that additional experience apart from law. I think will also help adding value and bringing diversity or a different view of something to the judges.
Okay. Yeah. Thank you. That's all.
Thank you, Commissioner Mulima.
Thank you so much, Honorable Chair. And Wakili, let's now move to something small on constitutional law. Could you be aware of a doctrine in constitutional law known as political question doctrine?
Yes.
Yeah. Briefly, what is it about?
This is when politicians bring political issues to courts. Instead of solving the political issues at their level, at the political level, instead they use the judiciary to fight out their political wars. And this gives the judiciary a bad name, and it is quite unfair to the judges and to the judiciary. So when you bring political issues to the judiciary, a politicization of the judiciary or judicialization of politics, whichever way you look at, where you take political issues to the judiciary and then make it a judicial issue. I think
that's basically the doctrine.
Yeah,
you're right.
Yeah.
That's a doctrine.
Yes.
Now, in terms of the applicability of that doctrine, I want you to zero down to how it's applied in America versus how it is applied in Kenya. How is it?
Well, in America, I think they are very much a two-party system, Republican and the Democrat. And depending on who appointed the judge during his presidency, judges are quote-unquote said to be leaning Republican or conservative or Democrat or liberal. In fact, to the extent that even the 9 judges are actually given, they're given their own quote-unquote names. Justice Kennedy is a liberal, Justice Thomas is a conservative, so they have that. And therefore, whatever issues are brought to them, even when they are not doing political issues, it is assumed and the tag is given as a political question. Whether it is about a constitutional right, it's about immigration, border security, or about health. In Kenya, we don't have that. Judges are appointed independent of any party, of any body. It is through a very clear, transparent process, and we don't subscribe to any political party or grouping. And we only rule on the basis of facts and the law.
Now, just a follow-up from your explanation. The way the American courts apply this doctrine is that they apply it wholly. Mm-hmm. As long as it's a political question, yes, it's a no-go zone, yes, yeah. Period.
Correct.
What about here?
We are not like that.
How different are we?
We look at the, if it's a matter affecting a constitutional right, our courts are more liberal than the hard stance taken by the U.S. federal courts in the political doctrine question, because it's a fundamental enforcement issue, and we look at both the process and the substance of the issue at hand, if it involves human rights protection.
Okay, we can go by that, and then something on just a minute. Something on conflict of laws. We are looking at two acts, the Law of Succession Act and the Matrimonial Property Act. And the Law of Succession Act in Kenya provides that when a husband, the husband in a monogamous marriage dies, the wife is only entitled to a life interest in respect of a property which is registered in the sole name of the husband. And the Matrimonial Property Act creates a rebuttable presumption that a property registered in the sole name of the husband is deemed to be held for the trust of the wife. You have gotten the two scenarios? Yes, yeah. Okay, good. Now, how will you resolve a dispute between the wife and her children after the death of the husband? In a case before you, where the wife contends that the property which was registered in the sole name of the husband is not part of the estate of the husband, since under the Matrimonial Causes Act, she wholly owns it because it was held in her trust by the husband. Yes. So it does not ascend to the estate of the husband. That is on one side. And then on the other side, the children are saying, no, this property is matrimonial, is not matrimonial, but it is forms the part of the estate of our father. Yes. And although you are our mother, you're only entitled to a life interest. How will you wriggle out in that instance?
I think I will overrule the wife. There is also the constructive trust for the children, which you have to assume exists also. Whether it is the wife was the only wife registered, the only person who was married to the man, and he had trust for her, interest for her the property. There is also the constructive trust we have to assume for the children. So she can't just come and claim all of it on her own.
Okay, so you will settle for the position that the wife is entitled to a life interest.
Yes, and the children also will have a right under the laws.
Okay, yeah. So you understand the essence of a life interest in property.
Yeah.
Meaning that what is it generally?
for as long as the property is generating income, she must be able to access and have a share of the property.
Life interest. You only have a life interest.
Yes. So for as long as she's alive.
Yes.
Yes.
Can she own that property?
As a life interest, no.
Yes.
She can't, yes.
Okay, good. Now, that being the position of what you are entitled to in a property in respect of a life interest, and having taken part in the constitutional making process in this country, do you find that position to be in consonance with the holistic approach of the Constitution?
No, it's not. I think when I said this is a people-centered constitution, I was a delegate of the Bomas conference. I was also a rapporteur on the Committee on Judiciary in 2002 when we were doing the first draft constitution. And in my own view, it is about equality and fairness of the law and the process. You have to be fair to the wife and also to the children. There's no law which can dispossess children to the advantage of the widow, or vice versa. My personal view is that there must be fairness and equity across all the board.
So you will, in this case, if I get you right, you will come up with an intermediate position, move away from the Law Succession Act, and also not go wholly by what the Matrimonial Properties Act provide.
I will go with the Law Succession Act.
So then the wife will get a life interest.
Yes.
Isn't it? Okay. Thank you.
It's a very technical question, Judge. I have to confess.
Thank you.
Yes.
We will now move to Commissioner Gutia.
Thank you, Chair. Good evening once again,
Good
Council.
evening, Commissioner.
We asked you to share with us your sample writings. Why do you think we asked for them? What were you trying to get out of your sample writings?
I think you are trying to understand my thinking, my philosophy of law, and philosophy of constitutional law, and how I will interpret laws.
Okay, you have shared with us 5, and there is a report, there is a personal reflection, there is a conference paper, and 3, you prepared them pre-2010.
Yeah.
And we have 1, you developed it in 2017, and another one you co-authored with another person in 2021. I have gone through them. You write well, you articulate issues well, especially on electoral governance.
Thank you.
And you have a clear, you provide clear reflection and an understanding of independence of constitutional bodies. However, they do not really tell us your contemporary legal writing skills. You've just mentioned we look at your writing, your sample writing, to understand your writing style. So we're not able to understand your appreciation and application of stare decisis, or they also do not disclose a discernible legal philosophy or your judgment writing ability. So my question to you is that, based on what you have provided, and taking note that your last interaction with court work, actual court work, is about 18 years ago, and we do appreciate the work you've done for the country at the governance level in different offices around the country and international public service. But looking at the sample writing, the last time you interacted with court was 18 years ago. What would the learning curve look like for you? Because you're looking at a judge who will immediately get into office and start working. Thank you.
Thank you, Commissioner. I have written a book which I will donate to the library of the judiciary. I think my learned friend Omwanza has read it. I think some of you may have also maybe seen snippets of the book. But the book actually contains part of my philosophy on what I think on law, especially my chapter on reflections, where I'm very candid about how I feel. But having said that, Commissioner, you know, when you are chairman of a commission, or even like IPOA, you still engage with the courts. As late as last month, I mean, 2 months ago, we were trying to stop the recruitment of the police. The National Police Service Commission initially wanted to have the power to recruit the police. There was a fight between them and the IG. A case came to court. A High Court judge ruled for the IG, and the IG quickly did the recruitment. We are involved because we are also interested party. We are oversight on the police. I prepared the affidavits. I filed the replying documentation. I have prepared for the cases. I read the law. So the fact that I have not come to court and won that, gone and talked, it's not actually you engage with the courts every day when you are leading these institutions, whether it is IPOA, whether it is IBC, whether it is KIPI. So I am very much aware about the judgments, and I know why we are appealing against that judgment. Even though police have been recruited, we still want to appeal because we want to settle certain legal issues about the human resource.
Okay, but you agree with me, you then have shared with us those court the court proceeding, no, pleading, sorry. Yeah. Okay. You have mentioned you work for IPOA, and there's been the general concern that at times IPOA oversights the police. There's the concern at times that the executive uses the national interest language to oppress the public. So how would you approach a competing claim of national and public interest through a constitutional lens?
Commissioner, first let me admit to you that policing the police is a very difficult job. It's not easy. There's always a part of it where they use security to override human rights, fundamental rights. And this issue becomes very critical and very acute during demonstrations, public order management, where people have got the right to assemble, to picket, and to protest. And then they say also, but we also have to maintain law and order, or rule of law. And so there's a tension that comes up. In my opinion, it is, once they bring up that issue, it is you look at the context, the facts. When people are not violent and they're just demonstrating, they're exercising their right. For example, there was a time when women were demonstrating against femicide, female killings along almost once one woman was killed every day or every month at one time, and then there was a big demonstration by female, and the police used tear gas on them and stun gun. It was a very serious case. So again, and I took a very personal interest in that because we felt that there was no threat to the police, there was no threat to the public. Why do you have to tear gas armless people who were just demonstrating, female activists? And so I will look at the facts of the case, the human rights involved, and the extent to which they can be able to derogate from that right. So it will be a context-based approach for me.
Which one is superior to the other? National interest or public interest?
I think public interest is superior. Yes.
Reason?
Yes. I think
Reason?
Because whatever you are calling national interest is for the public. Public owns everything. It's the public, the people. The people are sovereign.
I'm satisfied with that response. Thank you.
Thank you, Commissioner.
Thank you, Chair.
Yes. Thank you, Commissioner Rwanda.
Thank you, Chair. Good evening once again.
Good evening, Commissioner.
You have now been at IPOA for about
1
a
year.
year.
Yes.
A year and a month, I think.
December to December, 1 year and 1 month.
Okay.
Yeah.
Yeah, about a year and a month.
Yeah.
So, what would you say are some of your quick wins in the period that you've been at IPOA as an institution?
Well, when I came to IPOA, I came at a time when there was a lot of enforced disappearances and extrajudicial killings. We had the Gen Z demonstrations, and there was a lot of disquiet in the country about people who are missing. So the moment I was appointed, even when I took the oath, I remember the Chief Justice telling me, we need to know what's happening with these enforced disappearances. You guys have to get a hold of it. And we started that immediately. And I think over time, within that 1 year, we've been able to investigate those claims, allegations, find out those who are abducted. Some have been released. Unfortunately, some of them we have found they were dead, they were killed. We have completed our investigations and recommended to the DPP prosecution of certain officers. But that is with the DPP. He has only allowed so far 2 inquests out of the many files we have recommended. The other thing we have done when I came on board was to engage with the public in all our 8 regions, in Kisumu, Nyeri, Nakuru, Eldoret, Garissa, Mombasa. And again, talk to both state and non-state actors to understand what's happening in the policing world. And what we have come to understand is that there's a lot of reluctance and resistance by the police command, the police leadership on oversight. It's not an easy thing to push through civilian oversight. But what I have done myself, which the other 2 boards have not done, was to use a section of the law which makes IPOA give the power to prosecute all commanders who have declined or who have resisted to provide us with information or allow us to investigate or interrogate officers. So as a case study, I've recommended 2 commanders to be prosecuted. I think that has now changed. We're beginning to see a reversal. The police are cooperating. And I have also in the complaints mechanism, we have now used technology for the members of the public to be able to track their complaint. Before we didn't have that. We are trying to copy the judiciary and the DPP, where we have a system where you're able to track, once you file a complaint, where it is now. And I think that's something which is and finally we have, when I came into office, there was a lot of backlog. Like any other institution, which is given oversight mandate, whether it's anti-corruption, the judiciary, everywhere, there was a lot of backlog. So what I have done is we have asked for more money to recruit investigators. And we've been given some money, we've recruited some, we're going to recruit some more this year. But more importantly, what we did was creative role, where we found, for example, inspections team, those who go to inspect police stations and recommend remedies. They were not busy. We will call them and give them like the rapid response initiative, for example. We use them now to quickly open these files which are backlog, review them, recommend what should go for investigation. So I have tried to reduce the backlog. And finally, we have made stakeholder engagement our key. When we launched our strategic plan, which was kindly chaired by the Chief Justice as our chief guest, one of our pillars is to have stakeholder engagement. We never had that before. The public don't know what is IPOA, what is the role of IPOA. So we're trying to do that. And our commissioners and our staff have been going to all our regions, talking to the local FM stations, explaining what they can do with IPOA. So I think, although there's very low confidence in the police, and even low confidence in IPOA, I think for IPOA now we are trying to turn the tide. We're still down, but we are trying to turn it down. Yes.
I think it's commendable what you've been able to do in the few days, if I can call it that you've been at the helm of business at IPOA. I wonder, in the period you've been, have you had a performance evaluation yet?
Of IPOA?
Yes.
No, we of ourselves as commissioners.
But the institutional, no.
IPOA is not like a parastatal under the Ministry of Interior. There are parastatals like the Firearms Licensing Board, like the NGO Coordination Board, which are parastatals whose members are appointed by the minister. And so they have the regular annual evaluation, which is done by the SCAC, the State Cooperation Advisory Committee. But IPOA is an independent institution. And the commissioners are appointed through public participation, parliamentary approval, and gazettement. So we don't fall the parastatal tag, and therefore SCAC cannot come to do performance evaluation. It is ourselves which will do that.
I appreciate as much, because I know even as independent commissions and independent offices, we are in the process of developing a performance evaluation for the commissions.
Commissions, yeah.
Yes, but generally what I was looking at is if you have a framework for measuring what we've been able to achieve against the targets you've set for yourselves. You just shared with us the manner in the strategy you've put in place to clear backlog. So to measure how far you have gone, that you don't have a framework to do that.
We are required to report to Parliament and to the minister every half year, every 6 months. So I just signed off for the financial year ending on June 2025 with the performance indicators and the achievements, which I can share.
Okay, it will be great, because that's what I was looking out for. Yeah. Maybe to other things now concerning the office you want to join, I mean the institution that you want to join. Have you interacted with the SOJA?
Yes, the State of Judiciary.
Administration of Justice report.
State of Judiciary or the Administration
of Justice report.
This is the one that was issued last year.
Yes, towards the end of last year.
Yeah. I was invited as a member of the, by virtue of my office as chair of IPOA, we sit in the National Council for Administration of Justice.
Yes.
So I was there when it was being presented. I have the report. I have gone through it. It contains a lot of milestones and very successful success stories of the judiciary across the board.
Thank you for that. I take it as a compliment.
Yes.
But I'm concerned about whether you appraised yourself of what happens or what is happening in the Court of Appeal in terms of their performance. Did you get an opportunity to do that?
No, I can see though.
Okay, so you wouldn't know maybe the statistics?
For the Court of Appeal, no, I don't know.
You do not know. Okay. Some of the parameters that we measure in that report, especially in respect to specific courts, are the case clearance rate of that court, the backlog clearance rate of that court, and the Court of Appeal is not doing too well. So the question I have for you is, why do you think so?
Thank you, Commissioner. I have had occasion to meet with the judges of the Court of Appeal in a wedding of the daughter of Justice Warsame. I think some of you may have been invited. And some of them were there, and we had a chat about the work. And they have told me they have worked. They really have worked, and I'm sure my sister here will confirm that. They told me that there's a lot of work.
Yes.
There's even a rapid response initiative to try and remove the backlog, but they're still unable to. And I think the biggest number they would say is about the numbers.
It's their numbers.
In
that
every station you will have the 3 judges, for example, and even if one of them gets sick or goes on leave, it stalls. So you needed even one more person in that station. So it is about the numbers.
It is about numbers, and that is why we are carrying out the exercise we are currently engaging in.
Yes.
And I would want to hear from you if you are ready to join that team and to do what is expected of you of that court. What are some of the strategies you would employ to ensure that we are able to improve on the case clearance rate and the backlog clearance rate of the Court of Appeal?
I think if I join in the court, and I'm assuming that I'll be making judgment from those that I start hearing, unless I am told to maybe go back and help in the backlog. But I think generally when I am in court, I will make sure that I write my judgment as soon as possible, immediately after we are through with the case. And if I'm able to conference with my seniors, the colleagues who are there, who I'm going to learn from, and we agree with them on the overall judgment, then I can always agree to consent and have one judge write for all of us. That way, maybe you are able to speed up the judgment writing process, and use technology also to speed up the process of listening to the judgments, reading the submissions online if possible, and making judgments thereafter.
Okay, you talked about use of technology. Yeah. Even as you're talking about filing submissions online, that's still use of technology. That's basically one intervention. Any other? I'm not even asking you to be innovative. I just want to get it that you understand or you appreciate how the court is operating in terms of case management.
I will. For me, I will also want to take the files maybe over the weekend when I have my time at home, read them, and start preparing judgments.
You will find that is the SOP of all the courts. It's a standard operating procedure.
Procedures, yes.
Yes.
I'm sure judges who are here will know that. And so I will do that. I mean, I will have no other life apart from this now, because I'm married to it, I'm committed, and this is what I'm going to do.
Okay, thank you very much, and I wish you well.
Thank you very much, Commissioner.
Yes, thank you very much. We move on to Commissioner Kisotu.
Thank you very much, Honorable Chair. Chairman, I'll ask you a few questions.
Thank you.
Now, what do you think is the relationship between the resources allocated to the judiciary and service delivery? And can a judge also play a role in influencing the resource allocated to the judiciary?
Yes. Thank you, Commissioner. I think the Constitution principle is very clear. Funds follow function. If you give a function, you must be able to give the money, the funds, to be able to do that work and do it properly. And I think judiciary is the third arm of government. And the most important, it's actually our last line of defense in this constitutional republic. But it's not given its fair share. And I think the best way we can do is to ensure that, luckily now we have the fund, the judiciary fund. I know Treasury was very reluctant initially to allow this, as they always are. But this time, I think we have it. But the more important thing is to ensure the constitutional allocation for the judiciary is reached. And the only way we can do that is to ensure that we hold the executive accountable, because they are the ones who collect the taxes, collect the money. Parliament allocates, of course. But I think the judiciary may, as a judge, we have to be much more firm in giving orders to implement not anything additional. They allocated on the Constitution by law. If it is 0.4% of the GDP, so be it. But we know this is the amount of money we have collected, and this is our share. It's as simple as that.
Okay. So, and how will you, how do you respond to, prompt and effective use of resources that will be under you as a Court of Appeal judge?
I think public funds, public office, these are all public trust, which we are holding. And we must be able to use them in a manner that promotes the public interest. We are not going to use funds or money or vehicles or assets of the state or the judiciary for our own personal gains or personal errands, but for the purpose of work, enhancing the work and making sure that we are able to use the resources in a manner that brings dignity to the office you hold and the work you do.
Okay.
Yes.
Now, could you also explain to us the leadership and responsibilities under Chapter 6 of the Constitution and how you will apply them.
Thank you, Commissioner. In my 30 years plus experience, more than half of them were in leadership position. I've been honored to be a leader in IBC, in IIC, in KIPI, and now in IPOA. So almost 15 years. And I think leadership is a public trust. Again, people have to believe that what you say is what you do. The moment they see a hint of hypocrisy, that is it. You have killed your leadership capacity. So what you say and what you tell people must be that you must lead by example. What you say is what you are going to be held accountable for. So first is lead by example. Number two, treat people with respect. You must accept you are going to be also held accountable by your peers, by those you work with, by those you work for. You also must be sure that what you are doing is a public trust, and the public trust that also is looking at you. And so ultimately, like I said, what you do is what brings honor and dignity to the office that you hold.
Okay, fair enough. Now, lastly, in your 30 years of service, have you ever encountered a difficult ethical dilemma? And how did you go about it?
Yes, from IBC. No, even before IBC, when I was the managing partner of the law firm, I was approached by pirates. Pirates, these who in Somalia who are hijacking ships, and they wanted me to be a go-between for them as they negotiated with the Korean government, Korean embassy. I declined. There was a lot of money involved, and it was very tempting because that time it was the thing going on. There were a lot of money being paid to them. So it was an ethical issue, a question, and I chose the legal way to say no. I will not accept. When I was in IBC, of course, I've been approached many times to compromise. For example, the party list for nominated MPs or senators. Somebody will tell you, the party officials are getting money. The secretary generals or the chairmen of the parties are collecting money for this party list. If you can give you money also and help us, maybe bring our names forward, we can give you something. There are a lot of, and I have maintained a clean hand, because this is what they do with the party. That's their problem, because the party will eventually face the people, and the people are going to vote them out, whether they want it or not. So, but for me, I will always say no. And finally, in the book, I have explained a situation where one friend of mine, who I hold in high regard, came to me, and he was given a contract to be a broker for the ballot paper printing. And he was getting 60 million. And he offered me half if I would break the tender and give it to also his company. Again, I said no. He insulted me with a long text message, but that's how it was. And I have gone through a lot of this. The problem is, when you are least corrupt, is when you are going to be called the most corrupt. It is a very sad thing in this country. When you have done nothing. For example, I have not eaten any chicken, but you will hear chicken gate is Issack Hassan, the face of chicken gate. And I have not even eaten any leg or any wing. But the problem is that if you stand tall and strong and say no, sometimes you appear the only one out. It's very sad, but that's how it is.
So did you get over this chicken gate, I'm sorry to ask, that keep on coming up,
yes,
hanging on your head
Yes. Yeah, I know. I was even served by the JSC 2 complaints. The same people. And in fact, my lady Chief Justice, I was going to propose that maybe in future, when somebody files a complaint, and then a judge applicant responds, I think the response will be served on the complainant. It will really help, because some of the complaints that I've seen, they are so old. They are overtaken by events. This is a case which was involving chicken bribery of officials of IBC, so sorry, interim independent electoral commission, and a UK agent, a UK company, and their agent, and they were given the tenders to award. They were given tenders to procure election materials, ballot papers, and they were paying the money to the country, and in the email exchange, they were calling their bribe chicken. You know, when will our chicken come? When are we going to expect ours? You know, and the money came from UK. It came to Kenya, and the money was it came to KCB account. From there, it was given out to somebody else. So you can actually follow the money trail if there was a serious investigation going on. And those who took the money from KCB and give it out are there. So, Anti-Corruption Commission investigated the whole case. They charged some people. The case is still active. It's sub judice, but the CEO, the director of the account, the procurement manager, the agent, were all charged. And I was invited as a witness. I was prosecution witness number 24. I gave evidence in court. And when I came, before I came here, I requested Anti-Corruption Commission to give me a copy of my statement so that I can supply to the commission my statement. But it is still an active matter. It's going on. I think the last I had is that the CEO of Anti-Corruption was giving evidence to close the case. So I'm not sure whether they have been put on defense or not, but that's how it is. And yet this complaint that was filed ignores completely that there's a case, that people have been charged, that I'm a witness. Everything is ignored as if it's a new thing. And it's the same complainant who filed in 2022, 2024, and again this year. So,
but if I may ask, which one is this that you say is still pending? Because from the media, we know that they were fined, they were sentenced to imprisonment.
No, there were two corruption cases. One was procurement of biometric voter registration equipment, BVR, and this one is about ballot papers and election materials.
And the one that they were convicted
is the BVR.
Is that still pending? Is it on appeal? Or?
They are on appeal.
Okay.
Yeah. So my point is, I have never been involved in corruption, and the only thing that my name comes up with is Chicken Gate, because that's the only thing that anyone who wants to harm me or who wants to defame me, that's the only thing they can come up with, nothing else. In my 30 years of life, that's the only thing that keeps on coming up. And if I was involved in a corruption scandal, and we were going to give a name to the corruption, you are going to be giving me the bribe, I won't call it chicken. I will call it a camel or a cow or something else. I'm a pastoralist like you.
Okay. Commissioner Ziran?
Maybe CJ, just to clarify an issue. Thank you for clarifying that issue of the chicken gate scandal. But there is the allegation that persons were charged and convicted for bribing you and others that I don't want to mention under count 1 in a UK court. So your name appears in that particular charge sheet, and these persons who were charged, they were actually convicted on several counts, including that one. Maybe we may need to clarify. So there is proceedings in the UK, and the complaint that you say keeps coming is in relation to, there is a matter in the UK where you are, there are about 7 persons or so with a company.
the allegation count one is that they bribed officers of the then IEC.
Yeah.
You
yeah.
can't
Mm.
remember, yes. So
No.
that has always been the issue, not
Yeah,
the
but-
Kenyan context, the UK and it's a public record, so maybe you can say something about that.
Yeah, that is what he has annexed to the complaint. I'm talking about the one by Peter Makori. He has annexed the prosecutor's opening statement. He did not annex the judgment. You see, when a case is opening up and you charge people, it is for the prosecution to prove its case beyond reasonable doubt. What has been convicted is only 2 people. What they have charged in that case, I think, is more than 7. And if you read the judgment, eventually, he has acquitted some. He only convicted the father and the son, and the son, I think, is the one who served jail. So it was if I recall, it was a conspiracy to corrupt public officials. A conspiracy to corrupt. Like I said, in Kenya, we have the Mutual Legal Assistance, MLA. The Attorney General will tell you it is ongoing. Through that MLA, they were able to acquire all the documents from UK in here. It's now in court. It has been submitted, everything. The email correspondence, the tickets, everything. So it's just that one page that he keeps on bringing back. He doesn't give you the whole story. Yeah.
Yeah, thank you. Commissioner Zirani?
Thank you, Honorable CJ.
Sorry, CJ, just
Yeah,
so that we
okay,
don't
it's
lose the thought. Chair, I just wanted to clarify. Are you or are you not mentioned in the UK proceedings?
I'm not mentioned.
You are not mentioned. And what is it that the prosecutor there alleged or said?
He alleged that, if I remember the complaint, is a 60-page document. He alleged that the company paid additional money for bribes to the tender committee and to the other officials of IBC, of IIC, interim.
Yes.
Yes.
And did
he also claimed to have paid money for commissioners.
Okay.
Yeah.
So in terms of the tender committee, were you part of the tender committee?
I'm the chairman of the commission. Tender committee is appointed by the accounting officer.
Okay.
Accounting officer is the CEO. He appoints the tender committee, the evaluation committee, everything.
So you are
As
not
a commission,
part of it?
we only approve the budget and the procurement plan.
Okay.
Yeah.
Now, was there any proof of any commissioner having been bribed?
No, there was no proof. You see, what happens, and it still happens even now, is that when you procure ballot papers and you give the company, whether it is in UK, in Dubai, or Greece, like last time, commissioners and staff will go technically to go and supervise the printing. So you will miss them. You will see the commissioners there. But if you look at the law, the accounting officer is the one who is going to be the one who is going to appoint the tender committee, the evaluation, and eventually award the tender. He will only inform the commission what has been awarded.
Okay.
Yeah.
So which individuals in Kenya are charged?
In Kenya, they have charged the officer, the CEO, Mr. James Oswago, the procurement manager, the agent of the UK company, Trebi Oyembra, and the senator who is a person who is now a senator. By that time, she was just a commercial broker.
Okay.
Yeah.
Okay, that's all.
Okay, Commissioner Zirani?
Thank you, Chair. Now I believe it's my turn.
Yes,
Good
Tanya.
evening, Council. I have a few questions for you. We begin by you telling us, would you describe yourself as a leader or a manager, and why?
I'll think myself as a leader. From the moment I took over management of my law firm, when my partner Ibrahim was appointed judge, I took over as a managing partner. And since then, I have been leading institutions, whether it's my law firm or commissions. And I think as a leader, I have seen that if you invest in people, an institution will survive. If you invest in, like in my law firm, I invested in the associates I gave them a commission I gave them a target of fees to achieve, and anything above that, they were getting a commission. And all of a sudden, our income went up, and the business of the farm was very good. And the law firm of Ibrahim and Issack Advocates was very well known in the community, and had a lot of clientele. When I went into IIEC, Interim Independent Electoral Commission, I found a commission. Okay, ECK was disbanded. When the violence happened, Parliament passed a law, and the commissioners and the staff were sacked on one day, on 28th of December. We entered an office which had nobody, just the keys. And so initially we asked for 50 civil servants to be seconded to us, to enable us to restart the institution. But then I built the secretariat. As the CEO was earning more than me, because we were only interim. We were given 24 months to do work, set up a secretariat, conduct voter registration, and do a referendum. It was very clear. So we set up an institution. And IEBC that we have today was my creation. I invested in the people, and commissioners come and go, but the institution, the permanent civil service that we created, is one that I'm very proud of, and I'm very positive about them. And I think if you invest in people, as a leader, you will get the fruits.
Fair enough. Are there instances where you've had to use your managerial skills, drop the leadership, and now become a manager? Do you have any instances that has happened?
During elections, like I said, in elections, we appoint returning officers for the constituency and a returning officer for the county, CRO, the county returning officer. But to be able to put myself in the shoes of the returning officer, I used to go to whenever we were having by-elections, I used to go to the constituency and put myself in the shoe of the returning officer and stay with them at night, see how they were doing, how they were packing materials, what kind of food they were being given. I used to do that for almost by-elections that were happening under my watch. And so that when I'm in Nairobi now, and a returning officer calls from Wajir and says, we have no car, and we can't take people to the polling station, I understand what that means and what he's going to do. So that way I will be able to understand that. But by and large, I usually give people agency and freedom to do their work.
Okay.
Yeah.
In a situation where you have a member of staff who keeps absenting themselves from work, and every time they give different reasons,
yes.
And upon investigation you find out that this person is an alcoholic, they don't show up at work because most of the time they're intoxicated, how would you deal with that situation?
Well, I think coming to work under the influence is obviously an offense in the law, in the employment regulations. But I think in this day and age, it's fairer to have empathy and first understand why. Maybe get to talk to the individual concerned and perhaps understand why he's coming to work drunk. It could be that there's some social issue, a family issue, or other personal issue, and then see whether you can help him come out of that before you apply the harsh and hard rule of the HR. Perhaps it is a mental health issue. So I will be more empathetic before and give a warning, give support where possible, even give help, counseling, or even rehabilitation before you can sack them.
Okay. My second last question, what do you do to ensure that the team that works directly under you remain engaged and motivated? On a daily basis, what do you do for your people?
I have personal assistants who have worked with me during my time IBC and IIC, and I have given them sometimes when they require opportunities to go out and, for example, short courses on legislative drafting or on leadership, allow them to also grow. Even though they are working with you directly, but you must give them space to also grow and develop themselves. And so I motivate them that way. Where I'm allowed to go to a conference or somewhere, a meeting, where they can also benefit, I will go with them and also carry them along. And that way, I'm able to let them also hear and see what I'm seeing, hear what I'm hearing, and learn with me. And that way, even if I go, they are able to maintain, build their capacity that way.
Okay. Finally, looking at your profile and the reports that you received, there's quite some good feedback from the public and even from your referees, where they say you're a very good timekeeper. Sometimes you arrive at the office at 7. That is very impressive. But how would you react to an allegation of being biased? What does that say, or how would you react to that?
I am not at all biased. I am very fair. People know me. People have worked with me. Will rarely tell you that Ahmed is a very unkind person or is a very unfair person. I am always, even when I am wrong, I will admit I am wrong, and I have even apologized to my junior staff where I felt that I misunderstood them. And so, but if bias is brought to my attention, and it is shown that, Chairman, you are biased, then I will of course apologize and make good on that. But generally, it's not in my nature. I am a believer. I know that out of this world also, I'm also going to be judged by the Almighty, and it's not for me to lie to him also. I cannot do that. Yes.
Okay. All right. Thank you, and I wish you the very best.
Thank you very much, Commissioner.
Vice Chair.
Fine, I'll ask you environmental issues to relax the technical issues you've been asked. Now, which are the Kenyan water towers? And why should we protect the water towers?
Kenya water towers include Mount Kenya, Mrima itself, Abadeas, Abadea Mountain, Mount Meru. And I think we need to protect these water towers because they feed us downstream. They provide the rainfall that we need, irrigation for our farms, water for the people. And so we must protect them at all costs, including the ecosystem around the towers.
What are the key environmental challenges facing Kenya at the moment?
I think it is deforestation. Deforestation, and it's very much more acute even in the Mau forest, Mau Summit. It has led to a lot of desalination and landslides coming because of that. And I think people have also encroached into the forests, human settlement, leading to a lot of human-wildlife conflict. And the forest also being for charcoal burning. That is a big challenge too. In northern Kenya, where we have the refugee camps, they have completely decimated all the forest, all the trees. The Dab and the Kakuma is more or less like a desert now. So these are serious problems that we are facing.
We need to remember Cherangani and,
yes.
and Mount Elgon as well.
Yes, yes.
Thank you very much.
Yeah.
Yes. Thank you very much, Commissioners. I think to wrap it up, and I'm sorry to go back to this, I think there is still an issue hanging in the air that I've read your book.
Yeah.
and I know how painful it is, the issue of the chicken gate for you, even from the perspective of your writing your own memoir, where you have come from, where you've reached, and these allegations that have not been substantiated, but they keep coming up. The UK matter, I think we were shown a charge sheet that said the persons who were charged for giving a bribe to A, B, C, D. D being Hassan Issack. That is how the charge sheet read. Now, I've not been able to see the judgment of the UK. Would you have it?
I can look for it,
because I haven't been able to see it. You know, charge sheets can contain anything like you said. But the crux of the matter is the judgment. What did the judge say about this particular charge and the particulars that were before the court? So I think this person who is complaining says that you were mentioned in the UK, there was a judgment and people were convicted. So it is important to highlight in that judgment that the evidence that touched on you, whatever happened to that evidence. But the Kenyan court, I think you are properly explaining yourself, but you can tell us how you can be able to explain yourself to the public and get out of this business of chicken.
No, when that matter was came to the public limelight, and the Daily Nation made a story about it, I actually engaged lawyers myself. Senior counsel Kamau Karori was my counsel, and he wrote to this court to get the judgment itself. And I think I can provide the judgment because I'm not at all involved in that judgment. Like I said, out of the people who have been charged, only 2 are convicted. And from my understanding, I can't remember everything now, but I know they were not convicted of bribing. They were convicted of conspiracy to bribe public officials. And the public officials were in Kenya, in Somaliland, and Mauritania. There were three countries, I think, involved. So what they have picked for you is just what they wanted to, the picture they wanted to paint. The truth is, that was the prosecutor's opening statement, and when he, even some Kenyan civil society who were very active during my time in 2013, went to that court to hear this case going on. And when in 2016, when Parliament found set up the joint committee, the Joint Select Committee on IEBC, the one chaired by Kiraiti Murungi and James Orengo, on how to deal with IEBC matters, nothing came up of those allegations. The DPP came and said we have no evidence, and the corruption said the same thing. Auditor General said the same thing. So why our own Anti-Corruption Commission took all that information from UK and have it here, after studying it, is when they decided to charge people. So why are we overlooking our own institution, what they have said, what they have done? And why do we have to give one letter, one complaint, precedence over everything else? By the time Anti-Corruption Commission decided to charge people, they have finished investigations. By the time the DPP has given the go-ahead for them to charge 1, 2, 3. In fact, I even think one of the guys was co-opted. He did a plea bargain. I think initially was charged, but later, because he agreed to testify and give information, he was converted into a witness. That is Peter Karani, if I recall, the procurement manager. But the point is, Anti-Corruption Commission is an institution in Kenya independent of judiciary and everybody else. And they have made a determination on who to charge. And this case is going on. There are 24 prosecution witnesses. I've given my evidence. I think the investigator from UK is the one who is being waited for to give evidence. He was requesting to give it on video, while the defense counsel wanted him to come in person. So this is going on, but for me, I've given my evidence in court. I was cross-examined by all the lawyers for the defense counsels. So, my leader, I want to urge that you give more importance to our jurisdiction and what our courts have said. But having said that, I will still provide the judgment of the court to
Very
this committee.
well. Yeah, because
Yes.
I
Because
heard
I want
you
it to be out of my hair.
Yes, I heard you say that we can also furnish the complainant with your response.
Yes, in fact, I want to ask the committee to do that
Okay.
to all of the complainants.
Okay.
There's one called Habling, something called David Habling. He calls himself a journalist based in Nairobi, but when I checked his Twitter page, it doesn't look like a journalist. It looks like a fake account.
I don't know how journalists look like, but it's okay.
No.
We'll leave it. We'll leave it there.
Yeah.
I think this. If you can actually send us that
Yeah.
judgment.
Yes, I will.
Because we've been looking for it, so that we can we can satisfy ourselves. Yes. I think this brings us to the end of this very robust engagement with you, Mr. Hassan.
Yeah.
I think now we can give you the floor, which we do
Yeah.
to a candidate.
Mm-hmm.
If you want to ask us any question or whatever you want to tell us, the floor is yours.
No, just to thank you for giving me this opportunity to come again and try my shot at the court. This is my third and probably my final attempt, and but I wish you all the best. The only thing I said is, in future, perhaps please serve the complainants with a response, so that you save people like us the pain of having to repeat the same information over and over again.
Very well.
Yes, yeah, I thank you otherwise. I wish you a lot of energy and health as you go on with the next interviews.
Thank you. Thank
Yes.
you. We need that. We also wish you all the best.
Yes.
We will get in touch with you when we complete the exercise.
Yes.
Have a very nice evening.
Thank you. You too, all of you. Can I take this?
Yes.
It's very beautiful.
The Constitution.
Can you?
Yeah.
Yes, yeah. Yeah. Yes.
The questions, your statement.